First of all, I thank Professor Bio for inviting me to this conference, and I thank Professor Carriage for introducing me to this conference. It's my pleasure and honor to be here. And then you may know that it is quite usual for a Japanese to start a presentation with apologies rather than a joke. Yes, I realized that the title of my presentation is very misleading, and I would say wrong. Amendments to the Japanese Act may mean that Japan already has an act on electronic video plating, and we are amending to that. That is not what I intended. Maybe I was drinking when I submitted my title, or maybe I was drinking bad wine, and a Croatian wine is not usually available in Japan. Anyway, so the correct title is here. So reforming Japanese law to introduce electronic transport documents. So we do not have it yet, but we have done all the work for that purpose. So I will introduce that process to you and think about, say, first of all, the very Japanese, a unique features of that work, and then think more broadly about how the harmonization idea that is commonly held in maritime law world is to be applied to this new form of futuristic form of documents, transport documents. So what has happened? Well, and to be very brief, the bill to introduce electronic transport documents is waiting, but not submitted to our Congress, which is usually called the Diet. Japanese Diet is the Congress. So, to be more specific, so from 2021. As usual, and we studied with a preparatory study group, kind of informal study group, I would say, chaired by Tomotaka Fujita, and some of you may know that he's now Vice President of Japanese MLA, and also a dedicated drafter, one of the dedicated drafters of Rotterdam Rules. So he chaired the study group and has a report. And then the Ministry of Justice formally launched the working group under the Legislative Council, again chaired by Tomotaka Fujita. And the working group concluded its work in August last year and submitted that report to the Legislative Council, which was immediately approved. And it is said, although it is the responsibility of the government agency, Ministry of Justice, to prepare a bill, it is said that the bill is already there. So, and initially we were told that at least early 2025, it should be submitted, tabled before the members of the Diet. It didn't happen. Then there was information that it is likely to be submitted to the Diet in the autumn session of Diet, but this year. It is not likely to happen now, and it has nothing to do with the bill or the report of the Legislative Council. Rather, politicians are occupied with many other things. In particular, our governing coalition is now a minority. I would say it's a minority, but it's not majority. It has lost its majority. So they're trying to reach out to other opposing party to have a new set of coalition, and so they are now busy with that. So, so let's forget about those political situation and look at, first of all, the report of the working group approved by the Legislative Council. So, and actually, experts needed to satisfy three things at the same time. So number one is that, and I will elaborate on the reason later, but number one is the working group try to conform to Antitrust model law on electronic transferable documents, MLETR, as much as possible. And number two, there was this kind of a bureaucratic, I would say, idea among at least the bureaucrats at the Ministry of Justice. By the way, Japan bureaucrats of Ministry of Justice are mostly judges temporarily seconded from the court of ministry. And they have this idea of retaining the law, the existing law on the paper bill of lading as much as possible and transpose them to the electronic bill of lading. And the third thing is that, so it is not simply a doctrinal work, or it is not simply kind of technical work. It was the initiative came from industry, not from the shipping industry, but from the platform a provider. So they needed to care for that demand as well. And so trying to satisfy all the three demands at the same time, there was kind of the big question about, okay, so now we are moving from paper document to electronic bill of lading. To what extent are they same with the paper document? And to what extent they are not? So it's quite obvious that we are moving from paper to digital data, so corporeal to incorporeal, non-corporeal object. And but on the other hand, the law on bill of lading and as negotiable instrument, or I would say I use the German term Wertpapier because Japanese law on this issue has been strongly influenced by the German doctrine. So it is not easy for lawyers to part with those way of thinking that they have long been familiar with. So that was kind of the contradicting demands or contradicting pressures posed on the experts dealing with this issue. So what are the solutions that have been adopted? Well, first of all, the report of the working group said that, okay, we will introduce electronic bill of lading records. So it is not an extension of a thing, or it is not an extension of a negotiable instrument. It is a data. It is a set of data, so electronic records. And of course, its issuance is permissible, so it means that an electronic bill of lading records are issued only when the cargo, the shipper, and the carrier consent to the issuance of the electronic records. So so it sticks to paper bill of lading, of course. Okay, so it is only when the shipper consents to it, or in the case of charter party, the charter, that the electronic records are issued. Then the question of what should be the equivalent to the concept of possession of paper document, as Professor Pavich mentioned in his presentation. And a English approach was a bit strange and extending the concept of possession to non-corporeal data. But Japan followed more the approach of ATR and introduced the concept of control. Then there was this heavy controversy about how to define control. I heard because those kind of controversies, at least some part of it took place between government agencies. several government agencies, and so not avert to outside observers. And but end result is that so control is defined as being in a position within the system as someone being the right holder over the goods, and no other person being in the same position. So number one, control is defined as a situation or position within the system. And number two, it apparently tries to say that they talk about exclusivity, although that word is not used. So the definition is almost kind of a self-contained. So a control is, after all, controlling the data under the law. So it's kind of defining itself in a kind of meaningless definition, I would say. So its definition, but it's only kind of describing what it is going to say under this law. And then there is the concept of delivery of electronic bill of lading record, and it introduced which is equivalent to the delivery of a paper bill of lading, and which means according to the report of the working group, so make a nominated person to control the electronic bill of lading under the system. So I have been controlling the data, but I will now take steps to make you control the data. That is the delivery of the electronic bill of lading. And then there is also electronic endorsement concept, and as distinguished from delivery of electronic bill of lading record, which is defined as recording the name of the delivering and delivered person, and with authentication. And authentication apparently refers to e-signature. So it's kind of the equivalent, or quite kind of transposing the concept of endorsement of paper bill of lading to the electronic digital world. So, other than that, other than these new concepts to be introduced, and many issues and many rules with regard to paper bill of lading are to be transposed to electronic bill of lading records. For example, the paper bill of lading, you have received a bill of lading and a shipped bill of lading, and then a received bill of lading with onboard notation. Okay, let's do it digitally. So received electronic bill of lading record and shipped electronic bill of lading record, and then you can add onboard notation to the received electronic bill of lading record. Similarly, types of electronic bill of lading record. Okay, so all the EBL record, named EBL record. So this is kind of straight BL. And then bearer EBL record and named bearer EBL record. Can you really think about that kind of thing? In a paper document, there could be things as that. So it's a bearer bill of lading, but the consignee's name is a printing on it. But in the case of a digital record, do we really need? But anyway, what we have with regard to paper bill of lading, let's keep it for electronic bill of lading as well. And then the carrier's duty is to deliver the goods against a surrender of electronic bill of lading record, but you do not use the word surrender. So how can you describe it? Okay, so a measure being taken to make the electronic bill of lading record unavailable. Then only after that the carrier shall deliver the goods to the holder of the electronic bill of lading record. Then the provision in the commercial code, by the way, in Japan, maritime law is one book within the commercial code. So several provisions with regard to paper bill of lading will be applied en bloc to electronic bill of lading record. Not only that, when you look at the civil code of Japan, then there is a chapter on negotiable instruments. And the relevant provisions within that chapter will again unblock and apply to the electronic bill of lading records. So all these things kind of transport from paper document bill of lading to electronic bill of lading records. Still, maybe Professor Fujita was successful in picking up this from the Rotterdam rules and introducing into this report of the working group, which is electronic bill of lading records will not be issued in multiple copies. So in the case of paper electronic paper bill of lading, of course, it is the common practice that a bill of lading will be issued in multiple copies, usually 3 copies, I understand. But for electronic bill of lading, that is not the case. So by way of kind of background, I must tell you, first of all, that in Asia, practically the industry, they rely heavily on the use of bill of lading. In fact, there are many short voyages, especially in East Asia, between Japan, Korea, China, and Taiwan. All these countries and regions can be traveled within a few days, only 2 or 3 days. So what is called the crisis of bill of lading is, yes, an actual problem. Still, the use of seaway bills is not very common, and the industry people stick to the use of bills of lading. As a result, this very strange practice developed, which is called surrendered bill of lading. And it is not surrendered upon delivery of the goods, but rather the bill of lading surrendered just after its issuance. So bill of lading is issued, but then collected by the carrier as soon as possible. So what does it mean? And it is of course not negotiable, because it is collected. The bill of lading is collected by the carrier, so there is no possibility for it to negotiate it. And even there is no role for it to play when the goods are delivered, because already the carrier has the bill of lading, so a delivery cannot be made against the production of this lading. So what does it mean? I can understand. But in Japanese court cases, Chinese court cases, and Korean court cases as well, from time to time, this surrendered bill of lading appears. So it seemed to be a kind of a practice seen in this region. Maybe I would say it's kind of colonial. So, and we learned the system of bill of lading. So we cannot depart from. You Europeans invented bill of lading. So if you find it is not suitable to the situation, then you can switch to another mechanism. But if you learn that system of bill of lading, we cannot depart from that. We stick to that and try to introduce this kind of very strange practice and to adapt that to the current situation. It is kind of supported by the survey, a very simple survey. I'm not sure whether that is statistically correct or not, but anyway, a simple survey was made by the preparatory study group, and according to that survey, shipping companies responded that in 80% cases they issue bills of lading. And then in 10% cases, surrendered bill of lading is issued. Seaway bills, paper or electronic, only in a much less proportion case. And then they respond that, well, electronic bill of lading, like Bolero type, a club system, electronic bill of lading, sometimes we are asked, but it's maybe once in a year or a few times in a year, and it is not very common at all. And freight forwarders even said that, no, we never issue electronic bill of lading. So that means, according to the Ministry of Justice, so this is the evidence. This is the evidence of that there is a problem, that there is the statutory and a scheme for electronic bill of lading is lacking. So that is the reason why we are going to introduce this new law to make electronic bill of lading acceptable to the industry people. I'm rather a skeptic, so even if after the law is introduced, and I'm not sure whether the use of dating will increase. Anyway, let's see. Now, I have to also say that this is not a pure commercial law issue. So I am a commercial law professor. I teach and research commercial law, and the Japanese system, as many other countries, commercial law is part of private law. But this reform is not limited to that. Actually, in two respects. One, for domestic context, and actually all these movements was started by the lobbying of a service provider. The company's name is TradeWatch. It's in fact a joint venture led by Entity Data, and their ambition is not only to introduce a platform for electronic bill of lading, but rather to become a platform for the whole supply chain and whole shipping procedures, including, so transport document is only one of the data that they are going to handle. They have a bigger ambition. And from that position, they say, okay, so we need a law to support our new service. And then the Japan Business Federation responded this movement and submitted a request to the government on the regulatory reform. So it was not a private law issue, it was a regulatory reform issue. And with this catchword or buzzword, society 5.0, whatever it may mean. And it's a buzzword to refer to a cyber-physical society. So if you are familiar with the Web 4.0 concept of the European Union, it's almost identical. So the issue was first debated in the Regulatory Reform Council, and the Regulatory Reform Council said, yes, we need this law. So, and then instructed the Ministry of Justice to prepare amendments to the Commercial Code. That is one context. The other totally different context is a group of 7 meetings, a group of 7, because that is outdated concept of 1970s, the developed, quote unquote, economies of those days, the US, UK, France, Germany, Italy, Canada, and Japan, and then the European Union observer, and Russia was once a part of it, but now expelled. And so G7 leaders said that we will endorse introducing legal system that is interoperable with the Astra's MLETR. I heard that it was the initiative of the UK government with their aspiration to maintain their position with regard to maritime maritime transport and maritime dispute resolution and a hub in the world. And anyway, so in that context, the G7 leaders said that, okay, we will push MLETR. So if it is a G7 leaders' consensus, Japan will follow. So that is the position. So we are faced by the industry demand, and we have to follow this a global promise, and then we will reform our commercial code on bill of lading. So this is the background. And then when it comes to the Ministry of Justice, their kind of meticulous way of working emerges. So politicians are very simple. And this is a phrase, a quote from the words of the minister in terms of digital affairs in 2020, back in 2021. He said that, okay, so we are not abolishing people bill of lading. We are only trying to permit issuance of electronic bill. So do it right now. It was back in 2021, still COVID restrictions were there. So with digitization, we need to move from paper to digital. So do it right now. But with the hands of meticulous Ministry of Justice bureaucrats, we will first of all ensure close conformity with the MLATR. So let's make a comparable table. So this MLATR element is introduced in Japan. This not in our report, but it does not mean that we do not comply with the MLATR. Rather, it is ensure that this element is also be met, and if this a report propose a lawmaking is done. So that kind of comparative table is made. And on the other hand, so let's think about all these conceivable issues, whether practical or not. For example, can a party having already electronic bill of lading demand changing it to paper bill of lading? Do you really want it? And if there is a paper document, and maybe party might wish to turn that into electronic bill of lading, but do you want to do the opposite? Anyway, we have to let that be done. Or what about, say, enforcement? Does it really take place among American law practitioners? And that the carrier, for example, does not follow a judgment rendered or an arbitral award being made by the tribunal, and does not follow it, and so you go to court and let the court pay leave to enforce over the bill of lading. I don't think that takes place in practice, but MOJ bureaucrats must say, okay, we have to think how you enforce your the right over electronic bill of lading, and even if that is on the blockchain, because that company, joint venture Trade Wars, intends to have electronic bill of lading on a blockchain. So that is what we have done so far in the past few years. Okay. So what are the lessons? Lesson is that, on the one hand, so with this digital electronic transport documents, harmonization in the broad sense is observed. So MLATR is at least a kind of a reference point, and Japan, as usual, looks at other jurisdictions, Singapore, UK. Okay, so there are many things that we can learn from them. Korea, we studied, but no, we don't want to follow Korean precedent, because Korean system is a rather central registry system, and we are now trying to introduce blockchain-based electronic bill of lading. So the harmonization is going to, but as someone said, God resides in the details. And in the details, there are kind of domestically peculiar features emerge, so they may constitute source of divergence. And the last question that has not been asked within the working group, but academics must think about, is that, do we really want functional equivalence? So transposing all those rules on paper documents to electronic bill of lading. Yes, MLATR says functional equivalence, but a functional equivalence means that what you do with digital data must be accepted as what has been done with the paper document. That is okay, but we are introducing digital or electronic things because there is advantage in it. Because we want to do something more than what we have done with the paper. In that case, do we really want functional equivalence? So we note that this new concept of medium neutrality emerged first with Unidroit working on warehouse receipt project, and then also in Astro when working on a negotiable cargo convention project. So we really need to think about the difference or relationship functional equivalence and medium neutrality theories. That is not overtly discussed within Japan, but it's intellectually very important issue. Thank you for your attention. I'm happy to respond to you.